I think we have enough people that have joined the webinar. I'm sure there'll be more coming in as we go along, but I'm going to get started. My name is Nancy Neerman. I am the Assistant Director of the Education Debt Consumer Assistance Program, or EDCAP. I'm here with Bea Circelli, who is from the New York Legal Assistance Group, or NYLAG. NYLAG is one of our network partners, and we'll talk a little bit more about that when we get into the presentation. So just a bit of housekeeping before we start. I will be doing the presentation. If you have any questions during the presentation, please type them into the Q&A box. Bea is going to be behind the scenes answering all your questions, whether it's about what I'm discussing or anything relating to student loans. Feel free to type those in. If we don't get to all the questions, because there's quite a few of you on this webinar today, if we don't get to all the questions, we can follow up with anything that we didn't answer at the end or after the session. Just so everybody is aware, the session is being recorded. You will get a copy of the recording and a copy of the deck after the presentation is over within a day or so. So with that, I am going to turn my video off and share my screen, and we can start the presentation. Okay, and Bea, if you could just confirm that you can see the screen.
Yep, I can see it.
Great. Okay, so we've titled this presentation Big Changes, Big Decisions, because as you probably are all well aware, that there are quite a few things taking place within the student loan world these days. And there could be very significant changes coming down the pike. We'll try to address some of those, what we see potentially coming, and things that you can actually do and take advantage of right now. So this is the agenda. I'm not going to go through it bullet point by bullet point. We'll just get to the items when we get them. I want to start by talking a little bit about our organization, EDCAP. We are a program initiative of the the Community Service Society, or CSS. CSS is a large nonprofit that's been active in various areas of nonprofit work for over 180 years, and the EdCap program was launched in late 2019 in response to the size of the student debt crisis, whether it be nationally or in New York. Student debt is the largest consumer debt after mortgages in this country. It's about a $1.7 trillion national issue. In New York State, there are about 2.5 million borrowers with close to $100 billion worth of debt. The other reason that this program was established, as many of you no doubt have come to realize, is that the system is incredibly complex, and has just become more and more complex since I've been doing this since 2019, with a lot of changes that happened during the Biden years, and then yet more changes that are about to come down the pike with the current administration. So we are a New York State funded service that is able to offer free one-on-one counseling in addition to these free webinars. And we're kind of your one-stop shop for anything, all things student loans. So we can help you with your repayment options. We can help you access forgiveness programs, apply for consolidations, deferments, and forbearances. We'll act as your advocate if you're having some kind of a dispute with your servicer or your lender. For those of you that may be in default or maybe on the brink of default, we can help you either get out of default or prevent you from going into default so that you're not subject to involuntary collections. And then a more recent service that we've been providing is really about things that happen prior to college. So whether it's filling out a FAFSA application or talking to students and parents about the best way to fund higher education with a minimal amount of debt, this is all part of our services. While the bulk of what we do covers federal debt, we also can help with private loans, private student loans, and direct to school debt or institutional debt. We also have a network of 11 organizations throughout the state that provide similar services to their respective communities. And one of those is NYLAG, and they are co-presenting with me today. So, Bea, if you want to take a minute to just talk a little bit about NYLAG, go ahead.
Yeah, of course. So, like Nancy said, I'm here with the New York Legal Assistance Group. We're a free civil legal services nonprofit, so we help low-income New Yorkers with a variety of things. We have an immigration unit, we do tenants' rights, and one of the things we do is consumer law. That's where I come in. I'm part of the Student Borrower Advocacy Project. So I'm an EdCap partner. I can help people with pretty much everything Nancy mentioned before. We're also able to help people that have to litigate an unpaid tuition lawsuit or an unpaid private student loan since we do legal services. Mm. So yeah, if you guys, have any questions about student loans or any of what I mentioned before, as I said, we do immigration, we do tenants' rights, we do consumer law, just feel free to reach out.
Okay, thank you so much. All right, so let's get on with the bulk of the presentation here. So I'm going to talk a little bit about some of the changes that we've seen announced, some of the changes that are coming down the pike. A lot of it is proposals at this point, but let's talk about all the things that have been discussed and are happening. So the first thing we want to address is the Department of Education workforce reduction. So Ed had cut its workforce by at least half, probably more than half at one point, if you factor in all the people that are just leaving and resigning. And those cuts really are having a very significant effect on certain aspects of what the Department of Education has done, particularly the Ombudsman's Department. These are the folks that will help student borrowers um, resolve any issues that they may have. That department has been gutted, and as well as other departments that oversee things like civil rights or some of the technology issues. So we've had periodic issues with the Federal Student Aid website. I mean, there's always been issues with the FSA website, but we're kind of anticipating that there may be more of those going forward. And even though a court recently ruled that the department could not fire all those people, and they've supposedly reinstated at least some of them. Our understanding is that the workers that were reinstated are really just not actually, they're being paid, but they're not actually doing anything. The department has appealed that, and their goal clearly is to just downsize. And their goal really is to eliminate the Department of Education. Whether or not they'll be able to do that, I don't know. But clearly, this move has taken away one path to help resolve disputes. Maybe not taken it away completely, but really severely limited their ability to help bars. So there's a couple of other options that we just put out here. Just remember, in the state of New York, the Department of Financial Services oversees loan servicers, so you can submit your student loan complaints to DFS. And I have a link to the portal here. The other thing that you can do, which we didn't do a lot of during the Biden administration, because the Biden administration itself were relatively responsive to disputes, is the Student Borrower Protection Center has created a toolkit for complaining through your elected officials, and this should be for a significant problem, but that is one avenue for you to perhaps submit your complaints and hopefully get some kind of resolution. The other announcement that you probably saw a few months ago was the intention to move the student loan portfolio to the Small Business Administration, or the SBA. Again, this is part of this administration's attempts to completely get rid of the Department of Education. Now, the president announced this, I believe, back in February, said it was going to happen immediately, and nothing has happened since then. And frankly, we don't know if anything will happen. I think this is also part of the most recent court order that would prevent them from doing this type of move. And we believe that to move anything to the SBA, they would need congressional approval. But we'll see what happens. The one thing that you should all understand is that if your loans do get moved to the SBA, nothing about your loans should change. So the dollar amounts don't change, the balances don't change, the interest rates don't change, the repayment options, forgiveness programs, all that stuff that you have access to now would not change just because a new agency was overseeing your loans. Anyway, whether or not this will happen in the future, to be seen. Stay tuned, and we'll let you know if something does happen. Of course, one of the biggest announcements back in April was that the Department of Education was planning to restart collections on defaulted federal student loans. So there are an estimated 5.5 million defaulted student loan borrowers currently. These are mostly borrowers who were in default prior to the forbearance and never took the opportunities that were provided during the forbearance to get themselves out of default. Now, what the department initially said is that it was going to be restarting collections on May 5th. And remember, collection activity on the vast majority of defaulted federal student debt has been paused for close to 5 years at this point. So um, what we know is that at the end of May, they said that they had collected about $100 million. And they announced that they were going to start first with Treasury offsets, and that would be Social Security offsets and tax refund intercepts. So the anticipation was that notices were going to go out in May, at least about Social Security offsets. And I know that some did. But then in early June, the department indicated through the press that they had placed a pause on these Social Security offsets. Um, However, they didn't mention anything about tax refund intercepts or wage garnishment. The original announcement was that they plan to send notices out about wage garnishment late summer. So you would expect maybe collections in the fall at some point. They didn't say anything about walking those back, so we're still anticipating that they're going to go forward with the wage garnishment component. Um, Everybody should understand that in addition to the 5.5 million borrowers that were already in default, there are another estimated 4 to 5 million borrowers that maybe are significantly delinquent at this time. So if you remember, after payments resumed in October of 2023, there was a 1 year grace period during which if you missed a payment, it didn't really count against you in any meaningful financial way. So it didn't count towards delinquencies. It didn't count towards defaults. You weren't getting reported to the credit agencies, and you weren't being assessed any late fees. That all ended in November of 2024. So if you've not been paying your loans since November of 2024, you're getting to the point where obviously delinquencies have already been reported to the credit agencies, but you may be at risk of default. And we're going to talk more about default later on, and things to maybe do to avoid involuntary collections. So at this point, if you did get a Treasury offset notice about Social Security, you may want to reach out for help to determine whether or not you're actually being collected on. Again, they said that they were pausing these Social Security offsets. We'll have to see. In terms of tax refund intercepts, if you filed your 2024 taxes and already have received your refunds, that should be protected. They're not going to, our understanding is they're not going to claw back refunds that they've already sent out. However, if you filed your 2024 taxes and have not received a refund, or you haven't filed your 2024 taxes yet and you were expecting a refund, you may be at risk. In terms of Social Security, if you have Social Security and your loans are in default, even though they've paused the offsets, you want to take this time now to start figuring out ways to get yourself out of default, because eventually they will resume collections on Social Security, and you don't want to have that happen. In terms of litigation, so you probably know that the SAVE plan, which was a plan that was introduced by the Biden administration back in 2023, was by far the cheapest repayment plan for the vast majority of federal student loan borrowers. Unfortunately, there were several legal challenges, and in July of last year, an appeals court placed an injunction on the Department of Education, blocking them from basically doing anything in the SAVE plan. So everybody that was in the SAVE plan as of July of last year has been placed in a forbearance. It's called the SAVE forbearance. It's a special forbearance, and you will remain in that forbearance unless you A, take steps to now switch out of your SAVE plan, or B, until they resolve the legal issues. This is a non-interest bearing forbearance. However, the time spent in the forbearance does not count towards forgiveness. So it doesn't count towards IDR forgiveness, and it doesn't count towards PSLF. The Forbearance has recently been extended to October 31st. It was up until the last couple of weeks. It had been scheduled to end on July 31st. It's been extended now to October 31st. And if the legal issues are not resolved by October 31st, um, then it will be extended again. So, and the other thing I would think is also, frankly, even if the forbearance does end at the end of October, it's unlikely that anybody in the Save Plan currently would have to actually make a payment until the very end of the year, possibly not until next year. There's just logistical things that has to happen between the end of the forbearance and then getting all these people, and there's close to 8 million people in Save out of that plan. Online and paper applications for income-driven repayment plans are available now. Not only are they available, but they are starting to process these applications. So for a short period of time last year and earlier this year, either the paper applications or both the paper and the online applications were unavailable. Um, those have been reinstated, but they haven't, for the most part, over the last year. They have not processed IDR applications. They are just starting to do that now. There's probably an estimated backlog of some 2 million applications that need to be processed. So it's going to take a while to get through all of that, probably months. So if you're submitting these applications, and you can do that now, just beware that you might be facing some delays. Um, IDR forgiveness, that's the forgiveness that if you're enrolled in any one of the income-driven repayment plans, and when I say IDR, that's the umbrella term for 4 different plans. If you're enrolled in those plans for 20 or 25 years, you can have your loans forgiven after making 20 to 25 years of qualifying payments. There's no employment requirement in this particular forgiveness program. And public service loan forgiveness remains in place. Despite all the headlines, nothing to date has changed with public service loan forgiveness. So people who are pursuing PSLF, who are in the non-save plans like IBR or Payee or ICR, you can continue making your payments and getting credit. Recertification guidance. Anybody over the years, if you've been in an income-driven repayment plan, you'll know that you're supposed to recertify these plans annually. So every 12 months, you provide new information about your income, your family size, your tax filing status, and you get a new repayment plan, potentially with a different payment option or a different payment. Um, but recertification dates, because of COVID and then because of the save forbearance, have been pushed way back. They've been pushed out numerous times. Um, Now, what I'm going to say here really didn't apply for anybody that was in the save forbearance. Those recertification dates had been pushed back earlier and pushed back into 2026. Some are even out there in 2027. But what had happened earlier in the year, around February or so, was that borrowers that were in Payee, IBR, or ICR were bumping up against their recertification dates sometime in February. And this was also at a time when the IDR applications were not being processed. So what was happening is that people were told that they had to recertify their IDR plans, but the servicers weren't processing the applications. So what was happening was, it's not that people were getting kicked out of their IDR plans, it's just that the payments were resetting to a much higher number, generally something equivalent to what you would pay in the standard 10-year plan, and they would reset suddenly, and in many cases, people just couldn't afford to make the payments. So finally, in March, the department came out and gave some guidance about this recertification. I'm not going to go through all of this, and you can read all this when you get the deck in more detail. But I do want to highlight that if you submitted, um, or if you had a recertification date that was on or before February 20th of 2025, and you did not submit the certification application, or you did submit it, but your payment was still reset, you're going to have to submit a new recertification application. If you haven't done it already, you want to do it now to make sure that you're back on track and in the right plan. For all the other scenarios, the Department of Education was supposed to fix those things. At this point, anybody with a Department of Education held loan, so those are direct loans and certain FELP loans, anybody with those kinds of loans, your recertification dates are going to be no earlier than February of 2026. If you're still experiencing problems with that, you want to reach out to an advisor to get some help. And you want to make sure that you're monitoring your accounts. If necessary, you may have to request forbearances while they're fixing some of this stuff. By now, one would hope they would have fixed most of it, but you never know. In addition to the legal changes, there are a number of other changes that are potentially going to be happening from different areas. Well, we'll start with the legal changes, though. So the court ruling that we've been waiting for forever, it seems, is most likely going to eliminate the SAVE plan. It's pretty well accepted now within the student loan community that that SAVE plan is not going to survive the litigation. Um, and the litigation, while it focuses on SAVE, it also involves certain regulations that may affect other income-driven repayment plans, like whether or not you get weighted average credit when you consolidate for IDR forgiveness. PSLF is a different thing that's got its own rules. It's not affected by these legal challenges. The courts may also make a determination as to whether or not IDR forgiveness can be offered through the payee or ICR plans. So SAVE, payee, and ICR are all plans that were created by way of regulation. And what that means is that it's generally easier to make changes to plans that are introduced by regulation versus plans that are there by statute. The only current plan that's there by statute, meaning it's a law, a congressionally approved law, is the income-based repayment plan. Now, we're going to talk a little bit more about IDR forgiveness going forward, but even if you've earned credit in payee or ICR towards this program, and they say that you can no longer get that type of forgiveness through these programs, you still could get it through IBR if you transfer into that plan, and you won't lose the credit you've accumulated. Beyond the legal challenges, however, we've got the budget reconciliation process. So, and we also have something called negotiated rulemaking. Budget reconciliation is part of the big, beautiful bill that's being discussed by the Congress. Negotiated rulemaking is a separate process that's used by the Department of Education to make certain types of changes to programs. Some of the things that are coming out as a result of these proposals that we're hearing is replacing the current repayment options for future borrowers with just two plans. So just a version of the standard repayment plan. There would only be fixed repayments, and the payback periods would range from 10 to 25 years, depending on the size of the debt, or one new income-driven repayment plan that would offer forgiveness after 30 years, and would also be eligible for PSLF. They're also talking about making changes to existing IDR plans such as payee and ICR. That would be through negotiated rulemaking, or the budget reconciliation proposals are to eliminate the payee and ICR plans for future borrowers. They're also talking about getting rid of the PLUS loan program for graduates. So PLUS loans is a program that allows you to borrow up to the cost of attendance and stay within the federal system. And that's allowed graduate students to basically fund their entire education within the federal system without having to resort to private loans. And they're talking about putting limits on Parent Plus borrowers. And then changes through the negotiated rulemaking process to PSLF would really be focused on limits to certain types of employer eligibility. We think that these negotiations are going to sort of revolve around the presidential executive order that came out that wants to limit access to PSLF for employers that do certain things that basically disagree with the current administration's viewpoint. So they talked about organizations that support illegal immigration and organizations that support child abuse, which I think really has to go to organizations that have gender affirming policies. It's that kind of thing. The negotiated rulemaking process is supposed to be open to the public. It has been in the past. Whether the current process is open to the public, it's probably going to be open to the public. It just may be less accessible, but it's in the past been open for public commentary. So if you want to click on the link here, if you're interested in lending your voice to this process, there may be a way for you to do that. You can explore that by using this link. So bottom line, what should you do? We're going to give you some more concrete advice on how you should navigate certain things right now, but key takeaway is you want to make sure that you're keeping really good records for yourself. You really can't count on federal student aid or your loan servicers to make sure that they're consistently going to keep accurate records of your debt, particularly if things are going to transition and shift to different places. So we're recommending for all of our clients that you make sure that you're screenshotting and downloading your loan details, which you can do from federal student aid or your servicer account, your payment history, which you can get from your servicer accounts, information from the PSLF tracker from your federal student aid account if you're following PSLF, if you're pursuing PSLF, and any important notifications from your servicer inboxes. You want to repeat the process monthly, or if you're notified that your loans are going to be transferred to a different servicer or to the SBA. Okay, before I go on, Bea, do you want to see if there are any questions that you want to highlight or anything you want to add to what I said?
Yeah, of course. A lot of the questions so far have been about PSLF. There's a lot of interest in the buyback,
Mm.
which I know I answered a few of these already as they keep coming in. It is a little complicated. You can only get the buyback if you would get up to 120 credits after doing it. So you need enough forbearances to get
Yeah.
there.
And we're going to talk
And
about the buyback a little bit later in the presentation as well.
yeah, and outside of that, I did see one question if we have any guarantee that the SBA wouldn't privatize, raise interest, or just in general, if the student loans do go to the SBA, like if we have any guarantee that these changes won't happen for borrowers.
Well, first of all, I'm not going to guarantee anything because I'm not the government. Um, all indications are that that would not happen. Um, you know, is there any potential avenue for them to do that? Maybe, I'm not 100% sure. But the key thing is that they have to get to the SBA first. And there seems to be a legal hurdle in that that requires some kind of congressional approval, which so far clearly they don't have, and therefore nothing has happened to date.
Yeah, and another more of a comment than a question that I'm seeing a lot is people saying that their servicer informed them that they are accruing interest during the safe forbearance. Um, like during periods of forbearance, interest continues to accrue, something Mohila sent to a lot of people.
So yes, there actually was a notification that went out by Mohila. It was like a blanket notification that went out to all their clients about interest accrual. Once again, throwing all kinds of uncertainty, and it was misinformation. They even actually posted a notice on their website that this really didn't apply to borrowers that were in the SAVE program. So it was just kind of like when they typically periodically they send out these form letters that go to all of their clients. Not every single client of Mohila is in the save forbearance. So periodically, they may be notifying their clients that interest is accruing in your account if you're in a regular forbearance. If you're in the save forbearance, it should not be accruing. Um, However, I will say that we have seen mistakes in some of these people who are in save where interest is accruing. And when you see that, you need to notify your servicer and make sure that they correct that. The way you want to monitor that is by looking at your unpaid interest balance every month. It should, if you're in the save forbearance, it should not be changing. Now, just keep in mind that the if you had any unpaid interest before you enrolled in the save plan, that's going to carry through until you pay it off or until your loans are forgiven. So there are people that have unpaid interest on their accounts that are in the save program. It's just that while you've been in save and certainly while you've been in the forbearance, it should not be getting larger. So you want to look at that unpaid balance every month. If you're in the save forbearance and that balance is going up, you need to contact the servicer and tell them that you think the interest is not accruing, is accruing when it shouldn't be.
Yeah. And last bit before we move on, and I'll tackle the rest of the ones still pending via typing. But I just see someone who's an advocate saying that one of her clients called to consolidate out of default. When she calls the default resolution group, they say they see her loans, but when she checks online, she cannot submit the application. I have not seen that before. I just wanted to check if you have seen that, if that's a common thing, or if this is something we
Um,
should tackle one-on-one.
I have seen it. In fact, I just did one of these the other day. So the loan, it depends on whether they're saying there's a couple of things. Um, what I've seen and what my colleagues have all seen at EdCap, because we've been doing more of these recently, is that you can log into your federal student aid account. You see that you have defaulted loans, but when you go to do the consolidation online, there's nothing to consolidate. They say you have no loans to consolidate. However, you can do a couple of things. You can either manually add loans to the online consolidation, or you can just do a paper consolidation. I think if you're in those circumstances, you want to reach out for help with that. And whoever the advocate is that is bringing up this question, if you want to send me and shoot me an email after the presentation, we'll walk through it. You need to get some help with that, though, if you're a borrower that's trying to do that, because it can be done. It's just more laborious, let's put it that way. And frankly, this seems to be consistent with any type of defaulted loan. So they're showing up on federal student aid, but you can't, they don't come automatically up to, they don't automatically come up to be consolidated. If they're not showing up on federal student aid at all, which occasionally has been the case, then you have to contact default resolution group, get all the details, and submit a paper application. Okay,
That's
is
it.
that it?
Thank you. Yeah.
Thanks. Yeah. All right, so let's move on. I want to make sure I get through this presentation in about an hour. So talk a little bit about your strategy for tackling debt. So when we see our clients, generally clients will come to us with some kind of immediate issue. They need to get into a different repayment plan, or they're on the brink of going into default, or they need to get out of default. And we're always going to resolve the short-term issues. But we also want to make sure that people leave our sessions with a long-term strategy for getting rid of their debt, because after all, that's everybody's goal, is to eventually get rid of this debt. And what we've seen after 5.5 years of doing this, and meeting with thousands of clients, is that everybody pretty much fits into one of these three buckets in terms of strategy. So the first is to pay off your debt as quickly as possible. This is going to be for people who have balances who are relatively large, sorry, incomes that are relatively large in comparison to their balances. So they're able to make more than the required monthly payments, or make a lump sum payment to help pay the debt down. If it's your goal to pay off the debt completely, then the faster you do that, the less you're going to pay overall. It may mean that you're making higher payments on a monthly basis, or big lump sum payments. But if you have a loan that has a 10-year repayment period and you pay it off in 7 years, you're saving 3 years worth of interest. So you're paying less overall on the debt. The second bucket is probably where the vast majority of our clients lie, which is identify some kind of a forgiveness program that you're eligible for, and pay the minimum until such time as you receive that forgiveness. So that's going to be for people with high loan balances, low to moderate incomes, who are pursuing things like public service loan forgiveness or income-driven repayment forgiveness. Making extra payments when this is your strategy really doesn't make a whole lot of sense, because again, the idea is just pay the minimum, meet the requirements of the forgiveness program, get the loans discharged. And then the last bucket, which sounds a little bit sad, but we have it here for a reason, is to pay the minimum required until death do you part. And this is going to be mainly for older borrowers who maybe took out late in life loans for themselves, or they more recently, we've seen a lot of people with big Parent Plus bar balances that they took out for their kids, but they're older and they're either approaching retirement or in retirement. So they don't have the ability to do like a PSLF type program if they're eligible for it. And they may be faced with 20 to 25 years or more of payments to get the balances paid off. And if you're 50 or 60 or 70, that could mean you're paying for the rest of your life. So the idea here is to just find the cheapest repayment plan that you can find, make those payments. Um, and the reason that we put this up here is that a lot of people don't realize like that unlike a lot of consumer debt in this country, if you die, the loans do not, the burden and the obligation does not pass to your estate or to your beneficiaries. So you just make those monthly payments that you can afford until such time as you pass, knowing that it's not going to be a burden on your loved ones. And then in terms of repayment options for now, and this could all change in a few months' time, we'll have to see. There are two basic ways of making payments in the federal student loan system. There's the traditional plans where the payments are based on the size of the debt, the interest rate, and a predetermined payback period that can range anywhere from 10 to 30 years, depending on certain circumstances. Um, and the alternative to that would be the income-driven repayment plans or IDR plans. Again, that's the umbrella term to the different plans that we're going to talk about, which very often really have nothing to do with the size of the debt. It's based on your income, your family size, and your tax filing status. So there's pros and cons about each. And again, depending on your debt balance and your income, I can't say that there's one thing that fits everybody the best. Some people may do better in a traditional plan, and others will need to be in an income-driven repayment plan. If you're in a traditional plan, of course, there's limitations. Sometimes people just can't afford the payments, but they are easier to administer in the sense that you don't have to recertify on an annual basis. You just put in the plan, the payment is the payment, or the payment schedule is the schedule, depending on whether it's a graduated plan. And that's what you pay until you pay the entire thing off. The names of the traditional plans would be anything that's called standard, extended, graduated, or if on your servicer account you see something that says level plan, that's a version of traditional plan. The IDR plans do often offer affordable alternatives to the standard plans if you can't afford the standard plans. Right now, they offer forgiveness after 20 or 25 years of making payments, albeit that forgiveness seems to be on hold for the time being, but that is the rule for the time being, for right now. It's also, IDR plans are required if you're pursuing certain forgiveness programs like PSLF or income-driven repayment forgiveness. And you can adjust the payments if your income changes in between recertification dates. The downside to IDR, of course, is that you do have to go through this annual recertification process, which can be range from annoying to being an administrative hurdle for certain people. The interest accumulation, any plan except for the save plan, if your payment doesn't cover the interest that accrues on the account, which if you have a large balance and a moderate income, it often does not, then that unpaid interest continues to accrue on your balance. And that's the big issue with student loans when people complain about the fact that they're paying, and the balance is just going up and up. That typically doesn't happen with most loans. But in those cases where that's happening, in most cases, those people should be pursuing forgiveness programs. So the goal is not to pay off the entire debt. It's just still, nevertheless, disconcerting to see that loan balance continue to rise. The IDR plans that are currently in play right now would be income-based repayment or IBR, pay as you earn, payee, income contingent repayment, ICR, and then the SAVE plan, which is really on hold. You cannot enroll in the SAVE plan right now. Like I said earlier, that's probably going to go away. But IDR processing for all the other three plans has resumed. I did want to say a quick word about income-driven repayment forgiveness. So again, this is the forgiveness that you get by being enrolled in any one of those IDR plans after 20, 25 years without having an employment requirement. So during the Biden administration, they had something called the IDR account adjustment, which was a one-time account revision that gave you retroactive credit towards IDR forgiveness based on a set of relaxed rules. So you got credit for periods that you maybe have been in forbearance that you would have otherwise not gotten credit for, or periods that you weren't even in an IDR plan. It was a one-time thing. They you had to have direct loans or have filed a direct loan consolidation loan application by June 30th of last year in order to qualify. After which they did the count, and for a brief period of time, there was a tracker on um, your federal student aid account that showed the results of the IDR account adjustment. Unfortunately, the current administration took that tracker down. However, the raw data is still there and it can be retrieved. If you log into your federal student aid account at studentaid.gov, open up a separate tab in the same browser that you have your account logged into, and then you put this link, which you will get, into that separate tab in the browser. You're going to get this kind of ugly looking file here over to the right. You'll see this pretty print box at the top. You want to check that off. This is actually a prettier version of a really ugly version of this file. This is your raw data, which you're probably not going to be able to read off the top, but we can help you read it. We suggest that you run this, probably run it every month or so, copy and paste it, download it. It's your data. Save it, and if you need an expert to eventually interpret it for you, you can reach out to us or NYLAG, and we'd be happy to help you with that. So just as a reminder, the SAVE litigation is questioning potentially whether borrowers are going to be able to receive IDR forgiveness through the SAVE, PAYE, or ICR plans. But if you've accumulated credit through those plans and eventually they eliminate that path to forgiveness in those plans and you have to switch to IBR, if you're eligible for IBR, that accumulated credit would move to IBR. But stay tuned because a lot of things could change with all of these forgiveness programs and the plans that are offered itself going forward. So about PSLF, I know there's always a lot of questions about public service loan forgiveness. So PSLF makes requires that you make 120 qualifying monthly payments, so 10 years worth of payments, after which remaining loan balances are forgiven. And then a qualifying payment is defined as an on-time or payment made in full on or after October 1st, 2007. Anything before then doesn't count towards PSLF. This is when the PSLF program began. You must have direct loans. In general, you must be in an IDR plan. If not, payments in a standard 10-year fixed repayment plan also count towards PSLF. And you must be working an average of 30 hours for a qualifying employer, which is generally a nonprofit or a government. Payments don't have to be consecutive. They are cumulative, so you could work for 3 years in the private and the public sector, get 3 years worth of qualifying payments, move to the private sector for a couple of years, come back. You won't have lost the payments that you've accumulated. Couple key things to note: that when you are applying for forgiveness, so when you're submitting that last PSLF certification form, you must be meeting the employment requirements. So you must be working an average of 30 hours for a qualifying employer at the time you're requesting forgiveness. So if you're on the brink of 120 qualifying payments and you're thinking about retiring or leaving the public sector, make sure you file that form first before you do that. And then one of the best features of PSLF is that the forgiven balances are not taxable at the federal level, and in New York, they're not taxable at the state level. And that's a PSLF rule. So that's not something that is going to change as a result of litigation, or to the best of my knowledge, that's not going to change through the budget reconciliation process either. So the buyback, Bea mentioned this earlier. Somebody had a question about this, and lots of people have questions about the buyback. So the buyback is a new rule that was put in place in July of 2023, although really didn't become necessary until after the IDR account adjustment ended, which allows you to purchase PSLF credit for months spent in a disqualifying status. And that includes months spent in the SAVE forbearance. So But in order to do this, you must have 120 qualifying months of employment on record. That's not qualifying payments, just 120 qualifying months of employment on record. So you may need to submit a PSLF certification form to make sure that you're at that level. And then the months that you buy back have to get you to 120 qualifying payments. You can't purchase months prior to consolidation or months spent in a school deferment, grace period, or default. And the payments are supposed to be based on the payments that you were making in an IDR plan prior to entering the disqualifying status or immediately after exiting or the lower of the two. The big question mark here is how they are going to calculate those payments for the save forbearance because they're not allowed to bill borrowers at using the save formula. So that's going to be kind of an open question mark. The way to request the buyback, it's relatively simple. If you think you meet these requirements, you just log into your account and log into the PSLF reconsideration portal on studentaid.gov. There's a link right here, and then simply select the PSLF buyback option. That's all you have to do. You don't get to choose specific months. They will go back and assess which months are eligible, and then they're supposed to come send you a letter with a proposal saying you can buy these months back at whatever the rate is. Now, if you meet the requirements, you absolutely should go ahead and file the buyback. But we're going to caution everybody not to rely completely on the buyback because we didn't even know whether these applications were being processed. It was recently revealed that in April, they processed 1,500 applications and they have a backlog of about 50,000. That was as of April. And then increasingly, people are going to be submitting these applications. If that's the pace at which they process these applications, it literally could take years to get through the backlog. Apparently, it's a very manual process, and they probably literally have a handful of people that are actually doing it. So, unless they allocate more resources to it or find a way to automate it, you could be waiting a really long time to get the results of the buyback application. What you can do, though, if you're a PSLF borrower, is you can continue to verify your employment. So you can submit the PSLF certification forms, which do verify that you met the employment requirements for the program. You should do this using the PSLF help tool from the studentaid.gov account and by requesting an electronic signature from your employer. I can't stress that last part enough. The process was shifted to the Department of Education last year. Ever since then, anything submitted with a manual signature is languishing for months, and half the time it doesn't even look like they're getting processed. So, but those that are submitted with an electronic signature from their employer, these forms are getting processed really quickly. So we strongly, strongly urge that you use that method to submit these forms going forward. So we did want to provide you with a little bit of guidance for what you should be doing now as a borrower. Um, if you're in the save forbearance, so you don't have to, if you're in the save forbearance, you don't have to do anything really if you don't want to. Um, your loans are not, there's zero interest on your loans right now. They're not accruing interest, or they should not be accruing interest. And you don't have to make a payment at least until the end of October 2025, and probably not until the end of the year or later. Um, Now, there are people that do want to get out of the save forbearance. A lot of them are people who are pursuing PSLF that just want to get on with it. But if you're concerned that you're not going to be able to afford payments in a different plan, or you just don't want to make a payment right now, you can just remain in the save forbearance for the time being. Your loans are in good standing. You don't have to worry about it. But if you're pursuing PSLF and particularly if you're close to earning the 120 qualifying payments, if you're enrolled in IBR, Payee, or ICR, continue to make those payments and you'll continue to earn credit towards PSLF. If you're in the SAVE plan and you haven't already done so, maybe now's the time to think about filing an application to switch your plan. Now, we do recommend IBR because that's the one plan that's least likely to be impacted by legislation, or sorry, by legal issues. But if payee or ICR are cheaper for you and they're still available, PSLF has its own law, and that law says that all income-driven repayment plan payments are eligible for PSLF. So if payee and ICR are cheaper and you want to switch plans, you can switch to one of those plans. If IBR is the best option for you, you should use the IBR plan. You should also note that when you submit an IDR application, you should be placed in a processing forbearance for up to 2 months. That's different from the safe forbearance. And we have seen this happen with people who are in the safe forbearance. A processing forbearance will get credit for PSLF for up to 2 months. So that's the benefit of submitting a switch plan application. In addition to eventually being able to switch into a plan and make qualifying payment credits, you might get 2 months of processing forbearance for free. And then if you're eligible for the buyback, submit the buyback. Um, the last thing that you can try um, if you are close to 120 qualifying payments, and this isn't going to work for most people, but remember that payments in the 10-year standard fixed repayment plan do count towards PSLF. If that's a plan that you're eligible for and that you can afford, and you want to contact the servicer and ask them what the payment is, because it could be very high, that would be one way for you to earn your last couple of months of credit in for PSLF. But be aware that if you have consolidated loans, if your balance is $7,500 or more, you're not going to be eligible for the 10-year standard fixed plan. You're only eligible for more extended versions of that plan that don't count towards PSLF. If you're on one of the traditional standard plans and you've been trying to enroll in an IDR plan, unfortunately, you may have to request forbearances if you can't afford the standard plan while you're waiting to get enrolled in the IDR plan. So you just have to keep monitoring that and make sure that they eventually put you in a plan or put you on forbearance while you're waiting for the plan to process. And then, of course, if you need to recertify your IDR plan, you want to go back to the recertification page and just review those details. TPD, or Total and Permanent Disability Discharge, is a program that will discharge your federal debt if you have a mental or physical disability that essentially prevents you from earning a livable wage. This program used to be managed by Nelnet, regardless of where your loans were held. It's now shifted over to the Department of Education. There's a new portal. You can access it through the loan forgiveness tab on federal student aid. That's going to bring you to the TPD application page. And then there's 3 different ways that you could submit the application. You could do everything electronically, including if you're getting a medical certification, have your doctors or NPs or PAs sign off electronically, although you want to clear it with them first to make sure that they'll do that. Or you can get some manual signatures from your or manual doc or submit documents by uploading them on the online portal, or you can do the whole thing by PDF and mail it or fax it in or upload all that on your online portal. Okay, I'm going to stop there, Bea, before we go on to the last area, which is delinquency and default, and just see if there are any questions that we want to review.
So far, again, still a lot about PSLF. Just really quick, Nancy, what would you say right now is a quote unquote normal processing time for somebody who met their 120 months and submitted their final certification like early May?
Well, there's 2 things. If you submitted it with an electronic signature from your employer, the count should update relatively quickly. It still takes another few weeks, maybe up to a month, for the actual discharge to happen. It's hard to say what's normal right now because there's not a lot of normal going on. I've seen things get discharged pretty quickly from the time the applications were submitted. Again, if they use the electronic signature, from the time that they got the updated count to discharge was maybe 3 or 4 weeks. But then I've seen other people that have just been waiting a little bit longer. So it's a little bit hard to say. You have to keep, if you think if more than a month goes by and you haven't seen action, you probably want to check up on it. And frankly, if you submitted the last application with a manual signature, and it's been more than a month, I would submit another one with an electronic signature and see if it happens quicker that way.
Right. And the other question I'm seeing in chat is about the buyback amount calculation, because they usually will use what you would have paid at the time of the forbearance. But someone's asking if you're in the save forbearance, are they going to calculate it based off what you would have paid in save, or are they going to use a different
Well,
IDR plan?
that's what I said we don't know.
Yeah.
To the best of our knowledge, those 1,500 applications that were processed in April, none of them were processed for save forbearance payments. It's a nobody knows the answer to that question, and I'm not even sure if the Department of Education knows the answer to that question, which is another reason why it may take a very long time to process a lot of these applications. And which is why we, by the way, we recommend for people that are close to your 120, or even if you're like within 8 or 9 payments of your 120, um, the recommendation would be submit the buyback application, but also switch repayment plans and start making payments towards PSLF in your new plan and see which strategy hits first. Because I think the last thing you would probably want to do is if you're like 8 or 9 or 10 payments away, you don't want to be waiting for 2 years for that or 3 years for that buyback application to process.
Yeah. That was it.
Okay. All right, so I know we're getting close to time, but I do want to quickly address delinquency in default and collections. So when the department made its announcement about resuming collections, there seemed to be a fair amount of confusion amongst certain consumers about whether or not their loans were going to be subject to collections. Part of it was the way some of the releases were worded. If you have not been paying your student loans, you're going to have to start paying your student loans. Um, just rest assured that the only way you will ever be subject to involuntary collections is if your loans are actually in default. So if you're in repayment, but let's say you're on a $0 repayment plan and you weren't making payments, you're fine. Your loan is in good standing. If you're in a deferment or forbearance and you're not making payments, that's fine. When you're in a deferment or forbearance, your loan's in good standing. It's not defaulted. It's not going to be subject to collections. If you're in school or in the grace period, because we've had a lot of inquiries from kids that are in school saying, "Oh my God, I haven't paid my loans while I've been in school. Are they going to start taking my wages?" No, you're fine. You're in good standing. Now, if you're delinquent, you're not necessarily in good standing, but you're also not defaulted. So if you've missed more than one payment, if you've missed, if you haven't made a payment since November of last year, which is when the on-ramp grace period ended, you're getting close to the point where you could potentially be defaulting. You are at risk of default after 270 days or 9 months of non-payment. But if you're delinquent, if you're just delinquent, even if you're 8 months delinquent, you're not going to be subject to collections. But you're getting to that point where you need to do something to make sure you don't fall into default. 270 days or more, 330 days if it's a certain types of FFEL loans, then your loans become potentially defaulted, and that's when collections could resume. So if your loan's delinquent, what do you do? Again, you're not defaulted, but you know you're past due. You can contact the servicer and request a retroactive forbearance. So if you've been, let's say, delinquent for 5 months, they may go ahead and bring your loans current. So give you that forbearance up until that starts really 5 months ago, which also could help potentially with your credit score. Doesn't mean that they'll always do it, but you can certainly request it. If they do give you a retroactive forbearance or a forbearance going forward, which would at least prevent you from going further delinquent, you still are going to need to come up with a plan because remember, forbearances and deferments don't last forever. So you're going to have to come up with some long-term plan for paying back your loans, and that's where you're going to need to explore the IDR options. But if you still can't afford the IDR options for the time being, you could elect, if you're eligible, to be in, forbearances or deferments for a little bit longer until you sort out your situation. The whole key is to keep your loan in good standing to avoid the default. So what happens if you do default? So the consequences of default are fairly significant. The debt becomes payable in full immediately, which of course is a non-starter for, for most people. You're not eligible for any income-driven repayment plans, deferment, forbearance, and you can't earn credit towards forgiveness while you're in default. You're also not eligible for federal aid if you're thinking about going back to school. And then you could be subject to involuntary collections. And these come primarily in three ways, although there's some additional ways you can be collected upon. Your tax refunds can be intercepted. Your Social Security can be offset by up to 15% with a floor of $750, so they can't leave you less than $750. And your wages can be garnished up to 15% of your disposable pay. The government can actually also intercept funds that are owed to you from things like federal contracts or the sale of federal assets such as treasury bonds. And all of these things the government can generally do without taking you to court. These are called administrative collections. Um, if you think that you might be at risk of a collection, you can call this Treasury offset or program or top helpline or hotline to see if you're scheduled for collections. Most of these collections go through the Treasury Department. They're the ones that carry out the collections on behalf of the federal government. Now, the good news is if you are in default, there are two ways to get out of default within the federal student loan system. There is loan consolidation and loan rehabilitation. For consolidation, you'd be replacing your existing defaulted debt with new loans that are in good standing, and then you would make the payments on those loans in good standing. This process can generally be completed, I would say these days, probably 2 to 3 months. Um, when you have a defaulted federal student loan, you have two negative remarks on your credit report. You have the delinquencies that led up to the default, and then you have the default itself, which shows up as a collections item. If you do a loan consolidation, you will not remove either of those negative remarks from your credit report. But you will become eligible for all those benefits that you weren't eligible for once you complete the consolidation. And if there were any interest or fees, those could capitalize, meaning they could be added to your principal during the consolidation. For PSLF and IDR forgiveness credit, for PSLF, if you have PSLF credit and you consolidate, at this point, you wouldn't necessarily lose all your PSLF credit. You get what's called a weighted average retroactive credit when you consolidated. But if you're pursuing IDR forgiveness and you consolidate, you may lose any accumulated credit towards that forgiveness program. And then the number of times you can consolidate really depends on what your loan situation is. Um, Consolidation will stop existing offsets like Social Security offsets upon the completion of the consolidation. If you have an outstanding administrative wage garnishment or a court judgment, you cannot consolidate your loan. You would have to get those judgments set aside in order for you to consolidate the loan. The alternative to this is if you're not eligible for it, or if there are things in there that you don't want to have happen, you would use something called loan rehabilitation, where you make 9 monthly payments over a 10-month period. This is going to be a longer process, takes 10 to 12 months to complete. You're going to have to negotiate those payments with your debt collector, and there's a lot of paperwork involved in this. If you do complete a rehabilitation, the default status is removed from your credit report, but the delinquency is not, the delinquencies that led up to it. Um, it's going to, again, restore eligibility for all those things that you lost eligibility for. Interest may not capitalize unless you have a certain type of FFEL loan. And then with a loan rehabilitation, you do retain the existing loan. So if you have any accumulated credit towards PSLF or IDR forgiveness, you're not going to lose that in the process of loan rehabilitation. The number of times you can do a rehab, you can only successfully do it once. And it will stop a wage garnishment. So you can do a rehab if you have an administrative wage garnishment. It will stop that garnishment or an offset after five qualifying payments. But if you have a court judgment, again, you can't do either a loan rehabilitation or a loan consolidation. One quick note about the credit impact. Defaulted federal student loans will age off your credit report, uh, just like regular student loans after 7 years. However, it doesn't mean that you don't still owe the debt, which is kind of like the big difference between that and a private loan. So with when thinking about consolidation versus rehabilitation, if the default is very old, if it's 8 or 9 years old and it's not on the credit report, then that credit report factor issue really isn't a factor in determining which option to take. And then there are ways to contest an offset or garnishment. Mainly, when you get the notice, you have the right, in the case of a wage garnishment, to request a hearing, or in the case of a Social Security offset or tax refund intercept, you can request a reduction in that offset. The timeframes are a little bit different, but I think if you have any kind of default, you're trying to get out of default, or certainly if you've got some kind of a notice that you're about to be collected upon, you want to reach out for help um, from either the debt collector or come to an EdCap or a NYLAG to help walk you through that process. And that's it for the presentation. I just want to point out, and I think most of you are here because you already subscribed to the EdCap newsletter, but if you don't, when you get this presentation, at the bottom of the relevant links page, there is a link to our newsletter to help keep you informed about important developments within the federal student loan system. And then, of course, if you want to contact either NYLAG or EdCap for one-on-one help, we've got the contact information here in the back of the presentation. So I know I'm over, but I apologize for that. But I'm going to stop. I know still a lot of you are on the line. I'm going to stop here and see, Bea, if there's any last questions that we want to address.
Nope, we got through everything on the Q&A.
Okay, well, thank you so much. Thank you for your patience. Again, sorry for keeping you a little bit late. And if you have any questions, feel free. Let's see, I think we got somebody with a hand raised. Uh, Robel, I'm going to take your question and go ahead if you want to unmute yourself.
Thank you. Can you hear me?
Yes, we can hear you.
Okay, excellent. I kind of had asked it earlier about, it seems from what you had said, all in all, the forbearance period for those of us who were on SAVE would be almost 2 years by the time you estimated things will be resolved. Um,
I
and
don't think I said that, but
I, I, yeah, no, you didn't. I was just making the calculation. Like you were saying, like it probably won't be resolved until October and probably not until the end of the year, correct?
well, I have no idea when the court is going to make its decision. Frankly, most of us would have assumed that they would have made the decision by now.
Right.
So I really, at this point, have no idea when they're going to make the decision. In terms of when people might be able to go back into repayment, what I said is that even if it's resolved by October 31st, and assuming it's resolved in the way we think it's going to be resolved, meaning they're going to eliminate the SAVE program, then they have to transfer everybody from SAVE into a new payment plan. And that's going to take at least a couple of weeks, a couple of months. So that's why I'm saying, at best, people might not be forced to make a payment until the very end of the year or maybe sometime next year. The 2 year mark would run till like maybe, let's say, July of 2026.
Right. So, my question here is about buying back that time and how
Mhm.
that time may be calculated. Will they be using the IDR um, repayment options, or will they be just,
We don't,
you
this
know,
is the thing, we don't know because they've been blocked by the courts from using the SAVE calculation to bill anybody using the same formula. So if they have verified that you can buy back those months, how they're going to calculate the amount that you pay, at this point, we just don't know. The thing about the buyback, though, is that once you request a buyback, you're not forced to do it. So if you request a buyback and you get the offer, and the offer is ridiculously expensive, and you can do it cheaper by just, making payments in a different IDR plan, then you don't have to accept the buyback. But the other big question is we just don't know when you might get that offer. Literally could be years before you get the offer.
Right. I'm asking it in relation to PSLF and reaching that time.
Well, that's why we're recommending do both. Submit the buyback application, but also, request to switch your repayment plan and start making payments in a new plan, and just see which one gets you there faster.
Right. I'm not also trying to pay as much money as
That's,
say.
but that unfortunately, I can't give you a clear answer on how they're going to calculate the payments in the safe forbearance because nobody knows and they haven't shared.
Thank you so much.
You're welcome. All right, I'm going to take one other question and then, well, all right, I'll take two questions and then we're going to have to cut it off. Akila? Akila? Okay. I don't know if Akila is unable to unmute, but I cannot hear you. Okay, with that, I think we're going to have to wrap it up. You can always follow up with an email if you have additional questions or request a one-on-one. Again, thank you so much for attending, and for staying over with us. And we will be doing these probably every month, for a while. So we'll probably see some of you again. So, and thank you, Bea, so much for your help. Take
Of
care,
course.
everyone.
Thanks, everyone. Bye.
Bye.